burning issue. IPR is a burning issue. Nowadays, after formation of WTO, earlier it was there, but not that much important. After the WTO, it is so much gaining importance. So so proceed further. Okay.
इनको वो दे दीजिए ना सर को प्रेजेंटर. अच्छा नीचे गया
कर देगा माइक दे दो बस
आप ना कॉलर माइक लगा दीजिए ना सर. कॉलर माइक लगा दें.
कॉलर माइक होगा तो अच्छा.
हाँ इजी रहेगा.
So first question comes, what is IP? Then what is IPR? So previous I was hearing somebody was presenting in length these IPR issues. So first we should know what is IP. IP is reserved for type of property. If it is a property, then any rights related to this will be IPR. So the IP is reserved for types of property that results from creation of human mind, that is intellect, and it is differs as a having some rights. Then it will be treated as a IPR. So IPR are rights associated with intellectual property, which are product of human intellect, skill, and creativity. So, there are 7 IPRs. Out of 7, only 2 and 3. 2 are related to agriculture. One is patent, and second one is this GI, geographical indicators. So, what is the process? How will you patent your ideas or any findings? And then, how will you get GI of any particular species for your locality? So, see, the patents are available for any invention, whether products or process in all fields of technology, provided that they are innovative and novelty must be there, involving an inventive step, and that are capable of industrial use. If any patent, any idea, any findings, if it is not usable for the industry, then that will not be patented. And then second is geographical indicators. So these are indications which identify a good as originating in the territory of member, or a region or locality in that territory where a given quality, reputation, or other characteristics of good essentially attributable to its geographical origin. Suppose in our country, number of GI have been given. In Uttarakhand also, one GI has been given. Do you know which crop this GI has been assigned to our state? Tej Patta. So Tej Patta means cinnamon. Cinnamon has been assigned. Why it has been assigned? Because originally characteristics, if you see the characteristics of this Tej Patta, it is differing from Kerala Tej Patta. So Kerala is known for Tej Patta, not our. We are not known for Tej Patta. So though we have given GI for Cinnamon Tamala, instead of Tej Patta from curry leaf from Kerala. That is known for a spice state. So that is why GI is more important, and you can have GI for number of species throughout the country. But there are some limitations, some process, some procedure is there through which if you are going through that process, you will have this patent and GI simultaneously. So concept of this IPR, intellectual property, is defined as the product of mind and is considered similar to any property consisting of movable and movable things, wherein the proprietor or owner may use this property as he wishes, and nobody can lawfully use this property without his permission. This IPR issue originates when you have anything patented, so you have legal right to use it, and others simultaneously you are prohibiting not to use by others. So you will have some legal authority. You will have legal right when you have any patent. So see the after Gate Agreement 94 and WTO 95 is came into picture. So see, developing an effective multilateral trading system include trade in services for first time and includes protection of IPR. Yes, sir. Sorry, I didn't read more. Now sound is coming. Okay. So see, after WTO and GATE, tips has been introduced in that. With these tips, all these patent or even seven IPRs are being issued. Next. So IPR involves patent, copyright, trademark, design, GI, then protection of undisclosed information, as well as plant protection variety. And next. So this is the difference. You see trademark, copyright, patent, and they are being assigned for a different period of time with different procedure and with different purpose. Next. So what is patent? It is a sole right of inventor to exclude other from economically exploiting the invention, innovation for a limited period of time, means 20 years. If a patent is being granted for any ideas, any conclusion, any finding, it is for 20 years. So period is there. After that, you have to renew it with the licensing fee. So even before also, if you have patented something, so every year you have to pay some fees. It is not that you have had a patent of your idea. Suppose you have manufactured some machine, you have patented it, so it will not be remain in the patenting office without any charge. Every year you have to pay. Every year you have to pay. You bear the cost of this license every year. You are not paying cost, means that legal right which you have been assigned to you will be withdrawn. So that much legality will not be there if you will not pay the fees or fee whatever they are assigned. So Article 27 of TRIPS agreement mentions that the patent will be available for any inventions, whether product or process in all fields of technology, provided that they are number one, novelty must be there, new, then it should be involve an inventive step, and it should be non-obvious. And third one, applicability in the industry. Means industrial use, it should be, it should have industrial use, unless otherwise it will not be. After getting patent, if you will not serve the purpose of industrial use, it will not function. Means suppose you have patented something and there is no buyer. So it is a other kind of liability on you. You have to pay your fees every year and there is no buyer. So better you have to search first who is your buyer or industrial use. Patenting is in India, there are around 80 patents are there. In my institute also some around four, five patents we have also uh, been given. But out of four, five, most of are not having industrial use. So if any patent which have not qualified for characteristics, it will not serve the purpose. It will improve your biodata and not for the society. So better you think before the getting patent. You think what will be the commercial use further. So at least you will not be liable for the paying the fee. Right? Then what is the benefits out of it? Patentee has the exclusive right for the use of patent. He can take legal action against any infringement, any misuse, and he can commercially exploit its potential with the confidence that it cannot be copied or imitated without his permission during the period of patent. Patent means period is 20 years. So during that, if anybody is copying it, anybody is using without your permission, so there you can initiate legal action and he will be in trouble or in imprisonment or in jail. So this much right will be given to you as and when you will get patent of any idea. So this patent system in our country, this George Alfred E. Penny made the first application of for patent in India on 2nd September 1856. That is 150 years old now. After that, the Indian government started some patenting system governed by the Patent Act 1970. See, in our country started in 1970. Though uh, it was on global level, it started in 1995. So much earlier we have started. Even then we don't have that much of patent as Europeans have and that Americans have. So we are doing much. Our country people they are working hard, but very limited patents. Still, we have very limited patents. Lot of scope is there. See, if you see in Vedic period, even Newton has given this theory. Which theory Newton has given? Follow? Law? Laws of motion. Okay. In our Vedic period, somebody has given or not? Have you heard it? So see, that time there was no procedure for the getting patent. Even neem and turmeric, we could not get unless 94, 95 gate WTO was not there. Now just we revoke this patent of Europeans and Spanish against this turmeric and this neem. Otherwise, neem and turmeric, they have patented it. It's our food use. And I think all Vedic literature is full of this healing and antifungal properties of neem and turmeric. It is full of literature available, but nobody thought of whether we have to go for patenting or not. So doing much, thinking less is also a problem. Do equally whatever you think, you do it, but you pursue it the way it is needed. Means working and processing should go simultaneously. One way you are working hard, another way you think okay something will happen. I have done my part, other will do their part, but other will not do. You have to do. So there is no two way. Only one. You have to do this and that also. So what can be patented? The invention should be new, non-obvious, capable of industrial use. It includes manufacturing methods, process, machines, products, and their improvements, and also elite inventions. A patent is not granted if the invention is already available with the public in the form of published literature or prior common knowledge. So anything cannot be patented. It is already available in the. So this meme and fabric was already available in our Vedic literature. So that is why it was removed later on. And it must not be form of category specific. Category specifically declared non-patent. जरूरत नहीं है मुझे लगता हाँ विदाउट दिस माइक आई एम ऑडिबल or not?
I think, नहीं sir, हमारा नहीं होगा sir. Mic is muted, sir. Okay.
So these are the things which cannot be patented. Things which are frivolous, contrary, well established inventions, geopartizing, public order or model. A method of agriculture or method will not be patented. Suppose you are doing grafting, budding, cutting, so this will not be patented. And plants, animals, the whole or any part of their seeds, varieties, disease, essentially biological processes for production and propagation of plant and animal. These are not able to patent. These will not be patented if you go for patenting this following process. Ultimately, we will not be awarded any patent. So in USA there are different systems. In our country there are different process is quite different. But see, after WTO, more or less common platform has been put. So in USA, what is happening? The patent issued by the US Patent Trademark Office. The patent-like certificates they can be obtained by breeders under Plant Variety Protection Act. For getting the Plant Variety Protection Act, breeders required to exhibit the following traits in their varieties. That should be distinctiveness, uniformity, and stability. So these are the parameters on which your variety will be protected under this act. And for getting the patent of these, breeders required to provide evidence of novelty, that is inventiveness, and then non-obviousness, and then that is industrial use. Next, plant variety protection in India. That is the Plant Variety Protection and Farmer Right Act was passed in 2001. And in this plant variety, they are being protected by the effective genetic system, means one that is of its own time, and means there is no one is similar except that. Indian Parliament passed the Plant Variety Protection and Farmer Right Act in 2001. Based on that, central government has brought the biological diversity act, means, plant diversity or biodiversity act in 2008, and the headquarters is at Chennai. So these are the things. India is a party to the Convention on Biological Diversity, recognizing the sovereign right of the state to use their own biological resources. Convention expects parties to facilitate access to genetic resources by other parties, subject to national legislation and on mutually agreed upon terms. So, farmer right and breeder right both have been defined clearly. What farmer will have right? They can sow, they can save their variety, they can sow, they can resow, exchange, share. And what breeder will do it after having patent, they can sell. This farmer cannot sell. Breeder can sell. This money-oriented or business-oriented activity only patentee will do, not farmer will. So selling, marketing, distributing, importing, exporting, all right lies with breeders, not with farmers. So these are the clear-cut difference. It can be licensed, assigned, or sold for commercial considerations. Consumer will be benefited because better and cheaper product will become available in the market as more inventions will be encouraged. Research and development activities will receive a boost. After the expiry of the patent term, invention will be fully and freely available to the public. Suppose if you have patented something and the duration is 20 years, that is justed. So even if you are not repatenting it, it is fully available to the public and anyone can use it. There is no legal action after that. What is the term of patent? Okay, 20 years. Date of patent is the date when application is filed unless post dated or attended. If the application is not opposed, pre-grant representation determined in favor of the applicant, the patent is granted. Fact that the patent is granted is published in the Patent Office General. So where is the this patent office is at New Delhi? So items that are entitled for the protection under the IPR regime, any chemical formula that can be patented, company name, design of object, performance, images, logos, industrial processes, videos, trademarks, and ICs. Next. So these are the logos. Next. Who can use the patent? Only registered patentee or is authorized user that can use the patent. And when is a patent infringed, the unauthorized user copy. If you are using photocopy or replica of patented material, so it is only legal to use for individual use, not for sale. Commercialization is completely banned after the patent. So who can initiate action? Already the patentee can initiate the action against the user. If you are selling it, you will be put into the court. Next. So patent, okay, it will expire after 20 years. Patent is valid for 20 years. So this is the process. One can go through it and have the patent. Next, so patent is located at New Delhi. कि नीम का ये पेटेंट अभी रिवोक हुआ नीम एंड हल्दी बोथ दोनों का ये पेटेंट लोगों ने यूरोपियंस एंड स्पेनिश दे हैव बीन गिवन द पेटेंट आफ्टर appealing from the Indian authority under the uh, Indian Patent Act, they have revoked their patent. नीम और इसका हल्दी का दोनों का पेटेंट यूरोपियंस और स्पेनिश का कैंसिल कर दिया गया and it is again granted for India. So now you are having means India is having patent act. Before that, see traditional knowledge, digital library. Now India has traditional knowledge, digital library. After that, any literature is available, any documentation of everything is available under this what you call traditional knowledge digital library located at NDRI Lucknow. So now they are collecting all the informations after establishing this traditional knowledge digital library. Anyone is not allowed to have that because it is already published in digital library, preserved in digital library. So, neem and haldi now such type of patent will not arise in future. So, such type of dispute will not arise in future. That's, same thing India means patent, patent in Europe. What patent? Patent, patent means this turmeric and wheat. And another thing is leukoderma. Leukoderma, they have for treating the leukoderma are vitiligo. Vitiligo is a kind of skin disease. So using this cucumber juice for treating this vitiligo, or you can say leukoderma. So treating this leukoderma, it is a Indian, and that is why the title is India with patent patent. Otherwise, Europeans have patent of this leukoderma treatment using cucumber. Now it has been revoked and given to our country. So these are the offices located throughout the country, where you can proceed for the process. Next, this is the format after getting the patent. This type of format will be given. Next, the one patent has been granted at our institute, that is natural pollution and their mitigation methods are not adequately researched upon. Means, इन्होंने डॉक्टर आरसी यादव सीनियर colleague, he has filed a patent to use to minimize the effect of carbon dioxide being emitted from vehicle or means brick lanes. So when there are many sources, there may be many sources. This patent application claims to have dealt with the field problem frequently occurring with universal case of natural pollution. It is testing and simple method for eradicating which otherwise is complex. So they have furnished their justification through which they are able to apply the patent. What he did is, what is his idea? He has, suppose you are driving a vehicle, CO2 is being liberated or emitted from this engine. What is his idea is, can we minimize the smoke emission from the vehicle? If you have any idea, prove it. It is new idea. Then you go for patent. So what he did, he proposed many things. For vehicle, he proposed that if you add some calcium hydroxide after emission or before emission, in between, in the silencer, so that CO2 emission will be converted into calcium carbonate. So this way you are saving Earth. This way you are saving global warming. So like that, 3-4 figure he has suggested. Next, next. See here, new design of exhaust of vehicle. So see what he had done. He suggested that if you use calcium hydroxide before emission to the air, it is being converted into calcium carbonate, and this way you can at least increase the decrease the CO2 concentration being emitted into the atmosphere. Right now, around 400 ppm CO2 is there. Right now, in air, you see 400 ppm. It is also every day it is going to increase. So, CO2 concentration in the atmosphere it is being increasing. Lot of vehicles, many vehicles throughout our countries, everyone is running through the vehicle. So see how much CO2 we are emitting per day. At least not vehicle, we ourselves are also emitting CO2 through the respiration. So whether you are thinking how can you minimize the CO2 emission in the environment, if you are thinking and ways and means to reduce this emission, or you cannot reduce the emission, you can convert this emission. Suppose you are respiring, so respiration, how can you control? So only thing you can do, you just convert this through the tree biomass or vegetation biomass. So that much plant you have to plant in the field. The idea is to use calcium hydroxide before emission. At least CO2 emission will be minimized. That CO2 which is otherwise going into the atmosphere will be converted to calcium carbonate. Here you what is suggesting again, putting calcium hydroxide before the emission. So same idea is there. Next here idea is he is putting some different idea. He is recommending that you spray wherever you can reach, wherever you can reach, you add this calcium hydroxide before emission. Wherever it is not possible to control by your hand or with human management, you spray. Means you spray this calcium hydroxide so that whatever CO2 is available over the sky or in the atmosphere, that is going to convert it into calcium carbonate. So again, this is the idea only. You may have better idea, and in future you convert it into methane. Like chimney, again these brick kilns are there. So many brick manufacturing is there. A lot of CO2 is also being emitted from these chimneys. So their idea, if you spray, it will convert into calcium carbonate. So this way, so you see, this way, this is the one example. You may have your ideas, your findings, your thinking, your intellects, which can be converted to patent in due course of time. So now you see anything, the three parameters essential for patenting is novelty must be there, then non-obviousness must be there, then for industrial use. If three parameters, if any idea, any finding is qualifying, that will be patented very easily. Next. Yes. Second is copyright. Copyright is not directly linked with agriculture. But see, if you are, suppose you are doing research, you are publishing, thereafter copyright comes. So copyright in agriculture is byproduct of your research, not directly involved in agriculture, but it is a byproduct. Suppose you are doing research and very good publication you have brought, you want to copyright it. So every journal has copyright. If you want to publish your idea, your findings in any reputed journal internationally or nationally, so every journal has their rights. It is copyright, and you cannot copy, you cannot make replica of that. Suppose you publish a paper in impact factor 4, so NAS rating will be 10. I want to use your paper. I am asking, please share your published paper. You will not share. Suppose you will not share. Then I will go to Science Hub. I will go to Science Hub, and with this UI number, I will be able to access your paper. The moment I will access a paper through this Science Hub, I will be culprit. Anytime legal action you can initiate. But thing you should know, at least you should know, you will not know. Oh, the person is sitting in America and using Science Hub, accessing your paper, you are not knowing, so you cannot initiate action. The moment you came to know he has done this part, you can initiate legal action if you have copyright. So generally, all the publishing journals they have copyright. But even then, if you have a very good idea, you can also apply for copyright. So copyright reserves your right, like patent. Patent is also reserves your rights. Copyright also. Patent is only for patent is not for publications. It is for ideas. It is for findings, not for publications. Publication copyright is there. Copyright is a protection given by law to creators of original literary and or okay. Let's see. Copyright protection. So copyright ensures certain minimum safeguard of the rights of author over their creation, thereby protecting and rewarding creativity. And after coming this Copyright Act 1957, this protect original literary, dramatic, musical, and artistic works and cinematography, films, sound, recording from authorized use. Unlike the case with patent, copyright protects the expressions and not the ideas. There is no copyright in an idea. Suppose many things are available and you are without permission you are using. So after this act, legal action can be initiated. So there is no copyright in an idea. Idea का नहीं है, publication. So these classes of work for which copyright protection is available in India. Original literary, dramatic, musical, and artistic works for that is copyright will be given. Films, recordings, and whose rights are protected. Copyright protects the right of authors, creators, intellectual properties in the form of musical, dramatic, and artistic works, and cinematograph films, sound, recordings. Who is the first owner of copyright in a work? See, ordinarily, author is the first. Author means who is writing. So, author will be the first owner of copyright. And now, who is an author? In case of a literary or dramatic work, author means person who creates the work. Means musical work, composer, cinematography, producer, sound. These are the category of authors. Who can be a client of author? Author these are already defined. For copyright, these are the authors. Who is the owner of work produced during the course of author's employment? In the case of a work made in the course of author's employment under a contract of service or apprenticeship, the employer shall, in the absence of any agreement to the contrary, be the first owner of copyright therein. Moral rights of an author. Author of a work has the right to claim authorship of work, to restrain or claim damages in respect of any distortion, mutilation, or modification. Other act could be prejudicial to his honor or reputation. Moral rights are available to the authors even after the economic rights are assigned. The rights of a performer. Right to make a sound recording, visual recording of the performance. Right to reproduce sound recording, visual recording of the performance. Right to broadcast the performance. Right to communicate the performance to public otherwise than the broadcast. Yes, many things are there. After having copyright, who can use your published work or film or recording. So this all punishable. Next. Term of protection of a performer rights is for 25 years. The performer rights subsist for 25 years. Is copyright assignable? Yes. Copyright can be assignable. The owner of copyright is an existing work or the prospective owner of copyright in a future work may assign to any person copyright either wholly or partially, either givenly or subject. Whether copyright is assignable, yes, it can be assigned. And also, see, the copyright duration it lasts for 60 years. Once you get the copyright, after 60 years it will expire. So many things in our country, like copyright protection in our country, general rules is the copyright has 60 years. So Mahatma Gandhi, Navjeevan, next, Navjeevan Trust, all the rights has copyright by the Mahatma Gandhi during his period after death. Suppose 31st January 1948, you add 60 years. How much is it around 2008? So after 2008, whatever literature they have copyright is freely available to the public. They can use, they can make replica, they can sell it out. But before that, after assigning the copyright to the Gandhiji, no one, no one can use. So this is a trust, or you can say it is a given trust. All the rights were copyright were given to this trust. Whatever literature related to Mahatma Gandhi given to Navjeevan Trust. And after its death of this Mahatma Gandhi, means after even a duration of copyright period is 60 years, this was available to the public. Even you can use. There is no legal action. No one is have authority to initiate any legal action against us. When permission of copyright owner is not required for use of work, कभी नहीं होगा permission. See, when permission is not required for use of any copyrighted material, the purpose. Suppose you want to research, so you can use. But see, the uh, if you want to research, you can do it. If you want to criticize, you can also. So these are the parameters are the characteristics where you can do it. Collective administration of copyright. Collective administration of copyright concept where management and protection of copyright works are undertaken by the society of owner person to other. These societies, because of their organizational facilities, strength, are able to keep the vigil over the uses of work, monitor the collection of royalty for such use. India's membership in international conventions, reciprocal arrangements with similar societies in other countries. Copyright of foreign work product. अच्छा आप नहीं है
नहीं ट्राई टू कंक्लूड ताकि बच्चे भी
अच्छा जानना है बच्चों
हाँ बच्चों की भी
ओके
बस
ओके आप थोड़ा फास्ट करो
सर बस बन जाती है
अभी कितना टाइम है
सर 10 मिनट्स
So now trademark it is also it is a IPR issue. You can have the trademark. You have any good product, you can be assigned a trademark. Next, next. I will not elaborate many things. Trademark, otherwise it is not related to agriculture, but it is a part of IPR. So I listen to IM. आप बात करो और स्किप कर जाओ बहुत सारे स्किप कर जाओ हट जाओ हट जाओ ओके ठीक our part is GI and patent. So in length I discussed this patent and then GI. Many species have been assigned GI. See, Alfonso mango from Maharashtra have been assigned this GI. London Kerala banana it is also given GI. Darjeeling tea has been given GI. Then Nagpur mandarin. Then basmati rice. These are the burning issue where GI have been given for a particular region, this particular species. What are the parameters through which, after qualifying these steps, the species or product will be given GI. So these are the GI tag having a sign for many species or product. These are the all agriculture based products. In mango, Alfonso from south, and Dasari from Lucknow. So Dasari belt from Lucknow has been given another GI like Tej Patta or Curry leaf from Uttarakhand. So many GI has been sent. Only thing is maximum diversity of species must be there with different essence or different isolates. If any product or any species have different isolate over the prevailing species, that will be given a unique GI if it qualifies for GI. Then Pusa Basmati is a very dollar earning variety. Pusa Basmati 1121. Next, next, next. Then
बस का बोल दो
आप चल जाओ और एक okay. I can know your genius. You want to eat. You are hungry now. These are the IPR issues. Their offices located in different places. You can, if you have any idea, you go through the process. and follow and get the patent, copyright, trademark, whatever it is, GI for your country enrichment. See, the the IPR patent, all these seven parameter of IPR have the scope to, to present the growth of national of any country. So any Europeans have number of patents, number of GI tags. So their growth is being reflected by their patents and GIs. But we are not that much lucky to have this patent and GI to improve our you say GDP. We are not enough lucky to play our role in improving GDP of our country. Then thank you.
Thank you so much, sir. Any questions? Any questions from students?
No questions. Very good. I like it.
Thank you so much, sir, for your informative lecture. Now I request Dr. Deepajyoti Ma'am, Head Department of Zoology and member of the organizing committee of this workshop, to present memento to sir and honor him.
ये ऑफ कर दीजिए मनोज जी, ये पीछे का लाइट वो बंद कर दीजिए। सर आपने अपनी वो ले ली पेन? अभी अभी ले लीजिएगा ये वाली। आइए सर।
रुक जाओ मैम,
अच्छा।
बंद होने दो।
पेन ड्राइव
होती है बच्चों को।